Major breaking news, and this is important. The United States Court of Appeals for the 10th Circuit, overseeing states such as Colorado and Kansas, has just heard an oral argument involving whether or not machine guns, automatic firearms, are protected by the Second Amendment. And we're going to have to play you some clips from this argument and discuss it when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, this case involves the United States versus Morgan. United States versus Morgan. This is a case that got a lot of news attention because a federal district court judge, Judge Brooms, the district court judge out there in Kansas, decided that machine guns are protected arms under the Second Amendment as a matter of text, and then pointed out that the federal government had simply failed to show that machine guns could be banned or otherwise regulated consistent with the Second Amendment. Now, we're going to talk about that decision specifically, but in the meantime, I want to talk about this oral argument that just occurred in the 10th Circuit, because the United States government took an appeal in this case of U.S. versus Morgan to the United States Court of Appeals from the 10th Circuit, which again oversees the state of Kansas. And the federal government, in front of a 3-judge panel, argued that Tamori Morgan should be convicted, or at least should be tried, for allegedly possessing 2 types of automatic firearms. One firearm that she allegedly possessed is apparently an Anderson Manufacturing 300 caliber machine gun, and she also possessed a Glock that had in it, or with it, a Glock switch, converting that Glock handgun into a fully automatic handgun, according to the allegations in this criminal indictment, which was dismissed by Judge John Brooms down there in the District of Kansas. Then the U.S. government sought an appeal, and it was just argued before the U.S. Court of Appeals for the 10th Circuit. And boy, it was a doozy of an argument. So let me just go through some of the basics. As you know, under basic Heller and Bruin methodology, which is really the same case, the Bruin methodology of text first, then historical analysis, is the same analysis that the Heller case went through by the U.S. Supreme Court in 2008. All Bruin did was kind of elaborate on that exact same methodology in a sippy cup, paint by numbers fashion, so all these 400 some odd lower courts could get their act together and actually apply Heller correctly, because they were screwing up 6 ways to Sunday between the year of our Lord 2008 and 2022 when Bruin was decided. The district court judge said textually that machine guns were obviously arms. In the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. Machine guns are obviously firearms, therefore they're arms, and textually, any kind of regulation or restriction or tax or ban on machine guns implicates the text of the Second Amendment, obviously. Then the burden shifts, of course, to the government to show there's a historical tradition of regulating or otherwise banning these kinds of firearms. Obviously, the correct answer in this context is, because Heller was an arms ban case and dealt with what are protected arms, Heller should have been applied as the precedent, and the question becomes, as a matter of history, whether or not machine guns are dangerous and unusual weapons, conjunctive or not. And in this case, that's what the U.S. government tried to argue and sort of did in the district court, but then they apparently used the improper data from the National Firearms Act, pointing out there were 740,000 legally registered machine guns in the United States, but of course that's not technically accurate. The 740,000 number under the NFA includes all machine guns that are registered, including those that are registered to manufacturers, as well as state and local police departments, which also have an obligation to register their machine guns under the NFA. If you actually look at the civilian-owned machine guns, it's around 160 some odd thousand, a much smaller number than the 740,000, which you'll see why that's important. Now, before I get into some more specific arguments in the 10th Circuit, I do want to remind you of a couple things. You may not want to hear this, but it's not my job to make you happy. It's my job to make you smart. The reality is, as I've talked about before, and let me be clear, I don't like what I'm about to say. But I have to say it because it's for all of our own goods and for the good of the Second Amendment and America. And that is this. Right now, as we sit here today in 2025, we simply do not have anywhere close to 5 votes on the U.S. Supreme Court to say the machine guns are protected arms under the Second Amendment. We do not have the votes, and therefore we do not want any of these cases to go anywhere near the U.S. Supreme Court, because if the Supreme Court grants cert in one of these cases, not only will we 100% 100% lose the case and have another adverse decision by the Supreme Court against the Second Amendment. We also have a lost opportunity cost in the sense that rather than having the Second Amendment be heard favorably with another good ruling for the Second Amendment, we will potentially get a bad ruling out of the Supreme Court on the Second Amendment because we will 100% lose a case involving whether or not machine guns can be regulated and taxed and or banned under the Second Amendment. The answer will be yes, they can be. Maybe the Supreme Court will change its composition over the next several years in some favorable way, but right now that is not the world in which we live in. So with that said, everything I'm about to say, you must understand that context with what I'm saying here, because that's very important, because if I were advising the Department of Justice, I would be looking to get rid of these machine gun cases and not let them get anywhere near the U.S. Supreme Court in any respect. Now, with that said, let's carry on. Specifically, during this oral argument, you'll see the questions and the answers by the lawyers, and you tell me what you think about this. But the first thing I want to play for you is there's this confusion as to whether or not determining whether or not machine guns are protected arms under the Second Amendment. Does this occur at the textual level, where the burden of proof is arguably on the Second Amendment proponent, the rights claimant, in favor of the Second Amendment, or does it fall on the government at the historical level? The undeniably correct answer is that the decision as to whether or not a machine gun can be banned falls at the historical level. The reason why that's mission critical is because that means the burden of proof is on the government to demonstrate that a machine gun is dangerous and unusual. And this is a very big argument in this case, and you'll see why. But let's just start right here, right now, with the first discussion and back and forth as to whether or not the in common use test, which arises from history, occurs at the textual level or the historical level. Check this out now.
Well, the first step is to decide whether it's protected by the Second Amendment, isn't
Correct. Yes, Your Honor. But Heller specifically said that there are types of weapons that are, and weapons effectively are arms. There are types of weapons that are not protected by the Second Amendment.
So I guess I'm still struggling. I'm kind of I've got a formula. I got to plug it in. It seems like we're under step one here.
Your Honor, and I think that would be consistent with this court's decision in Rocky Mountain Gun Owners versus Polis.
Which we're bound by, right?
That's correct, Your Honor.
Again, the correct answer is the in common use test is derived from the history of banning the carrying of dangerous and unusual weapons, according to Heller. That obviously dictates what regulations are allowed. That speaks to history. The historical analysis occurs at the second part of the Bruin methodology, where the burden of proof is on the government. That is the correct answer. But let's go on to the next discussion here. There is a serious discussion here about gun technology, which kind of illustrates the point that it's very important, in my opinion, to really understand gun technology when you argue or get involved with any of these cases, because how these guns function can play a big role in helping courts understand what the heck is going on in these types of Second Amendment cases. Check out this clip from the court argument right here, right now.
So what they say is M16s and the like. So just to be clear, as an as-applied challenge, this is not an M16 rifle. This is essentially a semi-automatic rifle that can shoot automatically and a handgun that can shoot automatically. Now, those things are different. You can, like the M16 rifle, that's the military-style rifle that just feeds bullets in. You can shoot. With a semi-automatic rifle, there's a limit to how many bullets are going to come out because you don't have an unlimited clip, especially with a handgun. You're going to have less bullets coming out of the clip than you are, those 500 round things that are attached to machine guns. So if this were an M16, I agree, I'd have a problem. Now, the and the like, I don't know what that means. So it could mean, the cannon machine guns attached to airplanes. It doesn't mean a converted semi-automatic assault weapon. I don't know if it does.
All right, so the next clip I want to play for you deals with a typical question by anti-gun judges and anti-gunners, and people that are just somehow confused with how the Second Amendment works. And the question is, well, I don't understand. Is a shoulder-held or hand-held nuclear weapon, is a hand-held surface-to-air missile, are these protected arms under the Second Amendment? Well, the answer is how you analyze it. At the textual level, listen very carefully to me, folks. At the textual level, the right of the people to keep and bear arms shall not be infringed. The question is an arm or someone who wants to own it or carry it, keep or bear it, is that arm bearable? Can you carry it in your hands? That's the definition from the 18th century. That's the definition you must apply to the text of the Second Amendment. And therefore, machine guns are I should say, machine guns are arms textually. Surface-to-air missiles, to the extent you can hold them in your arms, would also be textually arms. So would nuclear weapons if you can hold them in your arms. It turns on at the textual level. Are the arms bearable? Which means, can you carry them? That's the textual analysis. Now, when you get to the historical analysis, you will be able to ban things like nuclear weapons, handheld nuclear weapons, surface-to-air missiles that are bearable. All these things can be banned, but the analysis to get it right, you do not lose the argument at the textual level because they're bearable arms. You lose these arguments to the extent you want to argue you cannot ban these things. These things can be banned, but they have to be done with the analysis at the historical level because these are obviously dangerous and unusual weapons by all measures, and therefore they can be banned. But the way it's done is you don't lose the case at the textual level, but at the historical level. Now, with that said, here was the discussion about this issue at the court.
We know that the Second Amendment has limits because the Supreme Court has told us so. Mm-hmm. And so we're trying to figure out what are those limits. And, the district court said it's an arm if you could carry it. I mean, if I had a surface-to-air missile that I can carry, is that protected by the Second Amendment? Would you think so?
A surface-to-air missile.
Yeah, they're shoulder launched.
Yeah.
Is that okay?
Or no?
What about a handheld nuclear weapon?
I mean, I think by handheld, with respect to firearms, what Bruin envisioned was something that looked like a firearm. That's how I interpret that language. So I don't interpret Bruin or Heller as talking about the cannon. That's not how I read the language. I guess somebody could. That seems a little, I don't know. I don't think the Supreme Court's going to say that.
So it has to look like a firearm?
Well, it has to be handheld in the sense that you can hold it in the hand and use it.
Hand grenade, fine.
Well, that's not a firearm. It's still an arm.
An arm. It's an arm.
So, I mean, I guess one way to think about it is, yes, that's protected by the Second Amendment because it is an arm, but it can be regulated, and a complete prohibition would be fine.
And why can it be regulated?
A grenade?
Yeah. What is the principle that we take and apply to other cases to know what can be banned and what can't?
So the principle it's a great question. The grenade would not be covered because it cannot be. I mean, that is something that you can't feasibly use in self-defense.
Why not? Somebody's attacking my home. I throw a grenade at them.
Blow up your home.
Machine gun. They're attacking my home. I mow them down with a machine gun. I mean, I can use it for self-defense.
Well, I think that the machine gun that you have to envision is the gun here that is not the M16 rifle that's just going to mow them down. I mean, this is essentially an AR-15.
It's a machine gun, right?
It fires automatically, correct?
Yes. Okay.
But it's not a gun. It's not a military style gun, like the M16 is my point.
Now, this next discussion shows just how important it is where the burden of proof lies. This is a discussion by a court judge, by one of the judges saying, how can I affirm the lower court if I don't know whether or not these guns are being owned by members of gangs? In other words, how do I know if these firearms are being possessed by law-abiding citizens for lawful purposes? How can I affirm and rule that machine guns are protected arms on the Second Amendment and they cannot be banned if I'm not able to make that distinction? And the answer, of course, is from the Second Amendment claimant's point of view, from the Second Amendment plaintiff's point of view, or in this case, the criminal defendant's point of view, it doesn't matter what you do, because when you're trying to figure out whether or not a weapon is in common use, which is part of the dangerous and unusual analysis, the burden of proof is on the government, because those standards undeniably come from the historical portion, the historical tradition of firearms regulation, right? So you've got to look at the historical tradition of firearms regulation, and that's where you get the dangerous and unusual standard that says if an arm is dangerous and unusual, you can ban it. If an arm is in common use, you cannot ban it because it's not dangerous and unusual, because it's not unusual. Here you have a judge that's totally confused because he's asking specifically, how do I know if these people are using guns legally or illegal, and therefore I can't rule in favor of the Second Amendment. Wrong, backwards, right? Because the in common use test is part of the historical analysis, the burden of proof is on the government, and therefore the burden of proof is on what? The government to prove these weapons are dangerous and unusual. So to the extent that machine guns are used exclusively, for example, by the Crips and the Bloods and the Yakuza and the Triad and all sorts of other illegal cartel members, whomever it is, the burden of proof to show that is true is not on the Second Amendment claimant, it's on the burden. The burden is borne by the government. And if the government can come forth and say that all these guns are owned by the, gang members, they can win. But if they can't do it, that means the burden of proof is in favor of freedom, in favor of the text of the Second Amendment, and the presumption that freedom prevails, that the Second Amendment prevails, does prevail, and the government loses. So to have a judge ask this question about how can I make a decision and affirm in favor of the Second Amendment without knowing this information means he doesn't understand the methodology and where the burden of proof lies, and that is terrible, frankly.
My only question is really, how can we affirm? You make really good arguments, as you always do, but how in the world could we say that, okay, well, we can look at this record and we can affirm based on this record because we can determine that it is reasonable for a district court to infer from the record that the 170,000 people that are registered owners of machine guns are not members of the Crips. They're not collectors. They're not, they're not, people that, are YouTubers that are, go around, boasting about their ability to, use these automatic weapons. These are people like you are inferring that are people like you and I that are trying to protect ourselves against intruders. And I don't know how in the world I can infer that. And I'm just being honest about, my struggle with how to affirm.
Well, I guess if you think this case turns on that you would need some sort of factual finding, and we don't have.
I shouldn't? Do you think I'm wrong to look at it that way?
I do think you're wrong. Well, I don't think you should. I don't think the in common use today test helps in this particular circumstance because of 922.0 itself. It just seems very odd to me that you would ask whether a gun that is prohibited from being possessed is in common use today. That doesn't make sense.
How do you square that with 627 of Heller?
And this last point is a discussion about whether or not a 10th Circuit, listen carefully, a 10th Circuit Court of Appeals decision sets precedent for this panel that they have to follow. And the answer is absolutely no, right? Because the Bruin methodology from 2022 is a precedent by the United States Supreme Court to the extent you as a judge conclude that the 10th Circuit Court of Appeals, an inferior court, to the extent you conclude that the inferior court has got the analysis wrong and inconsistent with Supreme Court precedent, obviously it is your job to follow the Supreme Court precedent because they are the superior court to the inferior 10th Circuit Court of Appeals. Nevertheless, this is the kind of dialogue we see back and forth. Check it out here.
That takes me back to something we were talking about earlier, to bring the Bruin framework back into the picture. This court in Rocky Mountain said that at Bruin Step 1, a court must determine whether the item at issue is an arm that is in common use for self-defense. Why doesn't that foreclose an argument that common use is a Bruin Step 2 inquiry?
Well, so that is a discussion of Bruin talking about Heller?
Well, it's Rocky Mountain
talking
about
Mountain.
Bruin.
Oh, correct. Yeah. That's tough. I mean, I don't disagree that one way to read Rocky Mountain is that it's putting the in common use test under Step 1. I don't disagree with that. I don't know that I agree that it should have done that, but I think it maybe did. Now, I sort of agree with the government. I'm not entirely sure I'm convinced why it matters what step we're in.
Well, doesn't it matter because Step 2, the burden is on the government?
Yeah.
Step 1, the burden is on you.
Well, so I guess the way I've said this in the brief is that because the in common use today test is still framed in historical terms to some extent. The burden would be on the government. I mean, in my mind, the burden for the plaintiff or the challenger to the defendant, the person challenging the law to show that their conduct falls within the Second Amendment is simple. It's the textual part of it. I mean, this is a bearable arm. Therefore, it's protected by the Second Amendment. Government, go. Justify the regulation. That's how it seems to work to me.
So there you have it, folks. We'll keep you informed if the Court of Appeals of the 10th Circuit makes a decision in the Morgan case soon. Be very interesting. I think if I was advising the Department of Justice, they should try to get rid of all these machine gun cases. You don't want any of these things close to the Supreme Court at all, in my opinion. But again, I don't control the Department of Justice. So there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @ProBoxingIron. Don't forget to follow me and subscribe both to YouTube and to Rumble. And I look forward to talking to you all again real soon here at the Four Boxes Diner.
Orders up. Table 2A.